Welcome back to Time Served, the channel that scans the docket so you don't have to. Today we're going to hear the plea hearing of Joshua Sandua, who was charged with beating a police officer while coming off a bus so bad he forced him into retirement. I just have to warn you, the audio on just the defendant is very low today. I tried my best. It truly doesn't ruin the clip at all. Like and subscribe, set your notifications to all. Let's roll, nerds.
Just let me get the papers in order. All right, the court is calling 2024 CR 3794 and 2024 CR 006799, State versus Joshua and Sandua. Could I have parties announce? And are you Joshua and Sandua? All right, you entered a plea in each of these cause numbers. According to your plea bargain agreement in each case, punishment is to be assessed at a cap of 10 years in the prison. The state is opposed to your applications. These cases will run concurrently. The state will take in consideration 2024 CR 006796, 2024 CR 006798, 2024 CR 007768. Have both parties had a chance to review the PSI report? State?
Yes, Your
Defense?
Yes, Your Honor.
Any objections to the PSI report? State? Defense?
One minor correction we saw in there, Judge, on the portion we saw about criminal history. I think it indicated that he had a juvenile record. He does not have a juvenile record. I think somebody just marked yes when they meant to mark no, but I didn't see anything else glaring that I saw that was problematic or objectionable.
All right. And then there was also a Tacoma screening completed and a TAP evaluation. Any objections to those documents? Defense?
No, Your Honor.
State? Okay. You have another witness?
Yes, Your Honor. We would call Joshua Sandua with the case.
Well, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. State your name for the record. All right, defense?
Joshua, we just heard a little bit from your mom about you. You know what we're here on today, correct? All right. There's some pretty serious offenses in front of this court, some felonies, and you're facing a decade's prison. You understand that? Okay. Let's start in the past. We're not trying to hide anything. You went to prison in the past. Is that correct? What'd you go to prison for? Sorry. And anything else? Or? Okay. And just to clarify, were you revoked from the drug probation at the same time you were sentenced to prison on the burglary? Okay. How long did you go to prison for? 2 years. Did you do the full term? Okay. When did you get out of prison? 22. So Joshua, since you got out of prison, have you used drugs or narcotics of any type? What were your drugs of choice, sir? Methamphetamines? When was the last time you used methamphetamines? Well, let me phrase it this way. When did you most recently get out of Fairfax jail? Last year, 2024? In that time, from December 2024 to today, we're almost at the end of March of 2025, have you used drugs? Your drug test today, would you be positive or negative? Sorry, no pun intended, but you're positive, you would be negative? Okay. Joshua.
For his son and accepting treatment. How convenient, right? Almost like accountability is an optional add-on to his version of reality. The assault. Now let's break this down. Joshua has tried to shift the narrative, claiming that the officer's injuries had nothing to do with him. He says it was all just a misunderstanding, that the officer somehow stumbled and took a fall for no reason. But let's be real, that doesn't make sense.
Not, I guess. I mean, you were there. I wasn't there. Your attorney wasn't there. The state wasn't there. So how did you try to do that?
I personally that I was being my way for crazy, just having something hurt itself, but we're trying to causing incidents.
So you're saying his injuries because he stumbled, and that had nothing to do with you. And if it didn't have anything to do with you, let me know. I am not holding it against you. I just am trying to figure out what your thoughts were on that day. Well, you're saying he stumbled. How did he stumble? Okay. All right. Any other questions, defense?
I can say it's found on this. That's, on the bus, there was two officers, correct? Okay. If you remember, Josh, did y'all all end up on the ground at some point? Were you inside the bus or outside the bus? It was outside the bus, so it's like on the sidewalk of the pavement or something? Okay. Did they try to rescue on the bus or off the bus?
On the bus, and then we moved outside the bus to 18 and I fell into the middle.
How long did all this happen from the point where they tried to arrest you to the point where you were tased? If you had to guess.
30 seconds.
Thank you. No further questions, Your Honor.
Any follow-up, State?
No, Your Honor.
All right. Any other witnesses?
Nothing further, defense, Your Honor, just argument.
All right. The court will hear argument. All right. Defense.
Your Honor, the defense is asking for probation, either deferred or even straight probation for the conviction in this matter. Even if that involves inpatient treatment, status for safety up front, we're not opposed to it, Your Honor. Mr. Enzaldua has a history, and it's unfortunate that we're here today again. I know you don't like to hear the word that mistakes were made and everything else. These were very unfortunate choices. Your Honor, I believe he is taking responsibility for what has happened. And the court has the discretion, the sole discretion as far as what needs to happen here. He's facing up to the decade in prison. That's a very long time. Person to follow. But I would suggest that he would be better served, the community would be better served if he was placed on probation with treatment. TEC is a place to go. There are certain cases that are warranted for it. However, in this particular case, Judge, I think it's clear there's a drug issue, drinking issue, everything else. In a short time he's been out, he's done okay. I think he will be successful on probation if he's granted. For those reasons, Your Honor, we're asking place him on probation. If the court sees fit to order him to inpatient treatment, but Your Honor, we're begging and pleading not to send him to prison.
Do you think you need inpatient treatment? Well, no, I mean, when you were talking before, you had requested outpatient treatment.
I've never had it before, so
All right. I don't think that probation is appropriate in this case, so I'm not going to grant probation. I'm going to find you guilty in each cause number. I'll hear any argument.
Officer sustained? Does he really expect us to believe that he had nothing to do with this? If that's the case, then why is the officer in such serious condition, having to retire early? The truth is clear. Joshua's actions were violent and directly led to the officer's injuries. And yet, he's trying to dodge any responsibility, playing the victim while the facts don't lie. The takeaway: at the end of the day, Joshua's story is just another.
For 10 years in prison, Judge. We have a wide range, anywhere from 2 years all the way up to 10 years. Your Honor, we would ask on the lower end that no more than 5 years in prison. Again, I think Mr. Enzaldua is somebody that suffers with demons. He would benefit from treatment. We understand where the court's coming from by not granting probation, but Judge, we're open, begging that the court sees that that's something less than 10 years. We would suggest a sentence of 5 years or less.
And state.
Judge, I mean, that was just previous and action.
So I'm looking at your previous history, which is a part of the PSI. You have a previous resisting arrest, search, or transportation. On that case, you were given deferred adjudication. You were revoked. Then you have a driving while intoxicated. You were given jail time. You have an evading arrest, detention, jail time. All right, this is what the court is going to do. Court is going to sentence you to 8 years in prison in each cause number. They will run concurrently, taking consideration 2024 CR 006796, 2024 CR 006798, 2024 CR 007768. I'm going to order no contact with the complainants and restitution in each cause number with the complainant. Did you review trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney.
And believe that he's a changed man. But how many times can someone claim they've turned over a new leaf when their track record screams otherwise? This is about accountability. Joshua's actions were wrong, and he needs to face the consequences.
Any call to community correction or anything along those lines.
So I had the opportunity to read the community corrections violation report that I believe Your Honor has as well. And that's not what's reflected in the community corrections violation.
Hang on. I have the sheriff's office report.
I have a bond violation of community corrections.
I do not have that.
Which I don't have. I don't know what it says, Your Honor, but I'm just asking if the court would please consider a lot.
Well, I got to figure out.
Mr. Levitt, and I can provide the court. Do you want me to email this over?
Yes, when you get a chance.
The classic, my tether wasn't working excuse. Maybe it's time to invest in a power bank, or better yet, a better decision-making process. Also, typing in the wrong code because of bad eyesight? That's creative, but it doesn't explain why the alarm was going off in the first place. And of course, conveniently, no records of contacting the proper authorities. If only people put this much effort into following the rules instead of crafting excuses.
That'd be great.
Yes, Mr. Levitt gave her very specific instructions. She was advised to charge it immediately after leaving the corrections, and she was told to, I'm still speaking, she was told to charge it for 2 hours. Mr. Levitt is the person that had to make contact with her while he was sending, he got an alert that the device had low battery. He attempted to contact her on the number that she provided him. That was unsuccessful. He started sending alarms and sirens repeatedly to the advice. Finally, the defendant, finally, I should say, is, I'm really bad at math, 6 hours later, the defendant calls from a different phone number. He goes over the instructions with her again and says, I've instructed them to charge it for 2 hours. She said she could not charge it for 2 hours. I told her it was her responsibility to keep the device charged and that it was critically low. And that's, if it gets critically low, dispatch will be contacted. They acknowledged this when the phone call ended. They then only charged it for 35 minutes. So she was given very clear directions on what to do. That was from June 10th, the first time it being low at 1 a.m. Then June 10th, 7:47 p.m., we received another low battery alert for the defendant. All attempts to reach the defendant were unsuccessful. At 7:48 p.m., Washington County Dispatch was contacted, advised of the violation, and was asked to have an officer respond to take the defendant into custody. Contacted by Deputy Mace, who was on scene with the defendant. They were claiming they had been trying to charge the device and were unable. Deputy Mace was told they needed to be arrested on the violation. The defendant had only charged for a total of 45 minutes in the last 5 days. At 9:05 p.m., the defendant was tracking at the Washington County Jail. So the device is working. In addition to this, my office just charged her with stalking in a separate case. In addition to this, my office requested a $10,000 cash surety bond at the time of charging this case. This case being today's case, we requested the 10,000 cash surety on putting shoes before your honor.
Mr. Kirwald?
I'm keeping the same argument, Your Honor. I'm asking.
Okay. Motion for bond reduction is denied. Bond will continue. This matter is revoked.
Judge, it's clarification. Is the bond, what are you, $2,000, 10%?
What do you have this on?
No.
I have 2,010% on this case.
And if she's released, it's on tether?
It's on tether. She'll have the same conditions.
Okay.
What? Oh, no, she is not going to sit there and mouth me. Her bond now is 25,000.
Really?
10%. Yeah, really. You want to keep going?